My name is Barton Morris. I'm the principal attorney at the Cannabis Legal Group. We're a law firm here, located here in Royal Oak, Michigan. We service cannabis businesses and seeking to get licensed in the cannabis industry. But what we also do is service and advise caregivers, medical marijuana caregivers. There's a lot of caregiving activity going on at this time. This is being recorded in August of 2020. That there is still so much caregiving activity. Let me talk about what a caregiver is. Of course, the Medical Marijuana Act of 2008 licensed and created medical marijuana caregivers, or individuals that are permitted to grow marijuana and produce and distribute marijuana to their registered patients. So the caregiver is permitted to have 5 patients registered through them under the Medical Marijuana Act through the Marijuana Regulatory Agency. And if that caregiver themselves is a patient, they can grow on behalf of 6 patients, 6 plants each, and up to 72 plants. Well, as many people know, that has become quite a moneymaker for quite a long time. There's caregivers that are growing up to 72 plants, and their harvests are being distributed in a multitude of ways. And even now, a lot of it is getting into the commercial market through licensed growers and then into the commercial market. That's going to end, as many people know, in October of this year. No longer will there be external transfers of that caregiver product into the commercial industry, so that's going to end. A lot of people are not even familiar with that, but if you're not, now you are. Yet caregivers and their activities are still in high demand for a lot of different reasons. So one of the questions that I've been getting a lot is to what degree and how can caregivers continue to operate, particularly in cities that have opted out for commercial marijuana, first of all, and second of all, how can a caregiver then obtain occupancy of like an industrial building in order to contain and operate their medical marijuana grows. The law has changed in this regard recently with a Michigan Supreme Court opinion that came down a couple months ago that says that municipalities now have the right to provide reasonable regulation on caregivers. So municipalities cannot outlaw caregivers. Caregiving activities are permitted by the Medical Marijuana Act, by state law, and municipalities cannot outlaw it. They cannot say that they don't want it in their cities, but they can regulate it in a reasonable manner. What that means hasn't been specifically defined, but I have my opinion about what a reasonable manner is. Like, for instance, a city can create an ordinance that says that they will only permit caregiving activities, let's say, in particular zones. Some cities had said that they would permit it in only residential zones. Some cities have said that they will permit it only in industrial zones. I think it's also reasonable for the cities to enact an ordinance that would permit them to inspect these caregiving grows to ensure that it's being done safely, that they're being performed and they're being operated safely, so that there's no unnecessary or unsafe manners in which that they're being operated, particularly with regard to electrical concerns, lighting, HVAC, just making sure that it's not causing a fire hazard. And it's probably also reasonable for municipalities to demand that these caregivers are registering with the state, with the city, with the municipality, so the municipality knows who's doing it and they're able to just keep an eye on it to make sure that it's not endangering the city. And there are some cities that have done this. Many have not. So the cities that have not thus far created an ordinance to regulate and to license caregivers, that means that regardless of whether they've opted out of recreational marijuana or medical marijuana commercial facilities, a caregiver is permitted to operate anywhere they would like legally in that particular city without restriction and in any manner they choose, as long as it's specifically pursuant to the Medical Marijuana Act and under the requirements of the Medical Marijuana Act, which are that each caregiver has to have their own enclosed and locked facility that has been restricted only to that caregiver and to the exclusion of everybody else. You cannot combine caregivers, but you can have multiple caregivers in one building, provided that each caregiver has their own separate enclosed and locked facility. And again, if a city does not have an ordinance that governs it, then these caregivers can operate and can operate in the manner that they choose as long as they're compliant with the Medical Marijuana Act. Now, then there's cities that have enacted ordinances, and some cities have said that you can only do it like in your home, and you can only use like 10 or 15 or 20% of the space in your home or in your basement in order to do it. And that so far has been deemed to be reasonable. So a couple questions come about. One, how do people know whether their city has enacted an ordinance, or a city in which that they are thinking about doing a caregiver grow, have they enacted an ordinance? And two, if they haven't, how do they get the city to issue an occupancy permit? Because let's say a caregiver wishes to, or multiple caregivers wish to operate in an industrial building, then well, they're going to have to perhaps do some upgrades to that building, and they're going to have to follow that city's ordinances regarding occupancy, which means there has to be an occupancy permit. And operating in a building without an occupancy permit is an infraction in and of itself, and can also be punished as well. Well, so let's talk about that. A city that doesn't have an ordinance and its caregiver wants to operate in an industrial building, let's say, and they need to get an occupancy permit, they simply go to the city and apply for one. Now, what will often happen is the city will say, oh, wait a second, we have opted out of medical and adult use marijuana. You're not allowed to create, we're not going to permit any type of commercial marijuana grow. But that's not what that caregiver is endeavoring to do, and it must be made clear to the municipality that this is not a commercial grow that would be controlled under an opt-out provision of that of that municipality's ordinance. In this case, it's a caregiving activity, and in this case, this municipality doesn't have an ordinance that governs these caregiving activities. Therefore, a city must accept an application for occupancy. They can't deny it. They can, because if they do, then that's a constitutional infraction upon the ability of somebody to be able to utilize their property in the manner of which that they have a right to do. Everybody has the constitutional right to use their property in any reasonable manner, as long as it doesn't interfere with somebody else's right to use their property next door. So when a city tries to tell a caregiver that they cannot operate in that building without an ordinance that governs it otherwise, that city is infringing on that landowner's right. So if they do in fact try to do that, then it's ripe for a lawsuit. That is a legal action that can be taken. We can take it to court, and we're going to win that action. Now, they don't want legal actions. Everybody's averse to a legal action, and so oftentimes by explaining it to the attorney that's representing the city, by explaining it to the city manager or whoever the appropriate party is that's going to make the decision to permit the application, that's what needs to be done. Of course, that's a lot of what I do here. You don't necessarily have to have a lawyer, but might be easier to have a lawyer make that argument on your behalf. But it's not always necessary. I've talked to a lot of city officials that completely understand it. They just try to discourage it. And the moment that they're forced with a situation where they have to comply, then oftentimes they do. Now, then there's situations where a city will have an ordinance, right? And sometimes that ordinance will be reasonable, and then sometimes that ordinance will not be reasonable. And what I mean by an unreasonable ordinance, the ordinance may say, well, we're going to permit a caregiver to operate, but that caregiver can only grow on behalf of one patient or under two patients, and they can only grow in somebody's basement, but only use 5% of the total usable floor space of that particular residential building. Something that is contrary to what the medical marijuana permits, and something that is simply just not reasonable. This again, is another source of potential litigation. And also something that's probably going to be a little bit more complicated, and something that the city is going to fight against, because the city has adopted this ordinance. They have had probably a lawyer advise them as to the legality of this ordinance, and somebody that, even myself, they're not just allow me to come in there and tell them otherwise. So sometimes that is going to cause litigation, and that litigation may be appealed up to the Supreme Court, which will then cause some law to be handed down about that. So we're still waiting for that. But the second question was, well, how do you know if your city has this ordinance? Go to your city's website, or go to that city's website and look up their ordinance. Almost every city that I've seen has a website, and they have a place where you can see their ordinances. And then when you get to, and you can also look under Municode, MUNICODE.com. That has most of the cities in the state of Michigan, their ordinances are there. And when you type in marijuana, sometimes you got to use an H, sometimes you use a J, sometimes it doesn't matter. Then, or you can type in caregiver, then that ordinance, or the lack thereof, will come up. And if there is one, then you can deal with it. If there's not one, then you know. Another place you might want to look is if it was enacted recently. They may say, oh, we just changed our law, we now have a new caregiver ordinance. You might want to look at the minutes of the city council or township board meetings, the recent ones anyway, where you might find that information as well. So I get a lot of questions about this, so I thought I'd record a video about it. Now I can just send people my video, and hopefully that will illuminate and educate you. And if you have any questions, feel free to continue to message me and my law firm. We will try to do what we can to provide everybody with the best legal information when it comes to the marijuana laws in the state of Michigan. My name is Barton Morris with the Cannabis Legal Group. Thank you for watching.